Legal terms. Part 2. Damages. Damages is the compensation awarded by the court to compensate the loss suffered by the aggrieved person. Or in other words, damages is the compensation to compensate the damage caused to the innocent party. Damage is what is caused. Damages is what is claimed. If A has suffered loss due to the act of B, the loss is called damage. If A then claims certain sum of money to compensate that loss, his claim is called damages. Defamation. Defamation is the injury caused to a person's fame and dignity. Libel and slander are the particular forms of it. Defamation may be caused either by expression of words, or by indication of signs, or by visible representations, gestures. Such an act must have been intended to harm the reputation of the person to whom it is directed or against whom it is leveled. It is not enough if the concerned person alone knows about it. The defamation or defamatory matter must be published, or at least communicated to person other than the one defamed. Defense. Defense is the specific denial of the plaintiff's allegations by the defendant. Defense is that thing which a man does in order to defend himself from the legal consequences of the proceedings instituted against him. It starts with the act of denial, and ends with the act of proof. A mere denial without its proof is no defense. De facto. This term means in fact. De facto implies a factual position without legal sanction used with reference to any person or a thing in existence. If a person is a guardian of a minor without there being any legal sanction for occupying such a position, that person is said to be de facto guardian of the minor. If a minor is in the actual care and custody of another person, who is neither natural guardian nor the appointed guardian of the said minor, then that person is called de facto guardian. De jure. This term is different from de facto. It implies a legal position with a legal sanction. For a minor who has no parents nor any person to take care and custody of him, if the court appoints a person of its choice as the minor's guardian, such a guardian is known as de jure guardian. This term means in law. Deposit. An act of receiving, keeping, preserving a thing belonging to another with his consent is known as deposit. The person in whose custody things are deposited does not become the owner of the things deposited. He has no obligation to return the things on the fulfillment of the stipulated condition. Though the thing comes to the possession of the other person, the person depositing the thing does not cease to be the owner of the thing. Deposit. An act of receiving, keeping, preserving a thing belonging to another with his consent is known as deposit. The person in whose custody things are deposited does not become the owner of the things deposited. He has no obligation to return the things on the fulfillment of the stipulated condition. Though the thing comes to the possession of the other person, the person depositing the thing does not cease to be the owner of the thing. Detenue. It implies the legal action for the recovery of chattels. If a person is detaining the things belonging to other without the latter's consent, the other person is entitled to an action in detenue. If a person is detaining the money of the other, then the other is entitled to an action in debt. Debt is an action for the recovery of money, and detenue is for chattels. Distress. It is another kind of legal action. If a person fails to do his obligation, the affected person can take the movable property of the defaulting person and keep it with him in order to compel the wrongdoer to perform the obligation. Until the obligation is performed, the things can be detained by the affected person. Such a right is known as right of distress. Earnest money. It is the sum of money deposited by one party to a contract, with the other party to the said contract for due performance of the first party's obligation. He guarantees his performance, which is secured by this earnest money. In case the performance is not done, the party depositing this earnest money is losing that money. Earnest money is paid as token of good faith, acknowledging the binding character of the bargain on penalty of forfeiture. Equity. Equity is the body of rules considered as governing all on account of their excellence and universality. The rules are not rigid. In its primary sense, equity is fairness of the rule of conduct, which ought to be followed by all. Law of equity is not a strict law. It concerns with the positive laws not according to their strict letter, but to other reasonable spirit. Estoppel. It means that in certain circumstances a party will not be allowed to show the truth in his own favor, when he has, by some act or deed or negligence, led the other party to believe that something else is the truth. Estoppel is a rule of civil actions. It has no application to criminal proceedings. When a person makes a declaration, or does an act with an intention to make the other person to believe a thing to be true, and that other believing it to be true has acted upon that belief, the first person cannot be allowed to deny the truth of that thing. Evidence. Facts stated by a person can be proved only by his evidence. A fact stated may be proved either by oral evidence or by documents. Statements made by witnesses in relation to matters of fact under inquiry are called oral evidence. Documents produced in relation to matter of fact under inquiry are called documentary evidence. If a fact is stated in the plain or written statement, it is called pleading. If the same fact is spoken by the plaintiff of the defendant, as the case may be, in the court in the witness box, it is called evidence. Execution. It is a process of court by which a decree passed by a trial court or appellate court is ordered to be enforced in a mode prescribed by the said order. When a court passes a decree directing the defendant in the suit to carry out certain obligation, the defendant has a legal liability to carry out the obligation. If he fails, then the court has the power to enforce the said decree in the matter permitted under the Civil Procedure Code. This term is also applicable to documents. A document is said to be executed if the authority of the document duly puts in signature subscribing to the contents of the document. Ex-Parte. The expression does carry with it the connotation that a court has proceeded with a case in the absence of the other party to the case. This expression is used to signify something done or said by one person not in the presence of his opponent. If a court passes any decree or order for dismissal, in the absence of one of the parties to the case, in favor of the either party present in the court, the decree or the order is said to be ex parte. Fraud. This term connotes actual dishonesty. Any act of suppression of facts, of suggestion of false thing, done with an intention to deceive the other party, is called fraud. When fraud is committed, the aggrieved party has a right to proceed against the fraudulent party for damages. In simple terms, this fraud may be described as procuring of advantage to oneself by causing a person with whom one deals to act upon a false belief.